So I'd like to welcome you all back again, and I'd just like to recap. My name is Catrina Heffernan, and I'm delighted to continue on facilitating the delivery of legal issues of medical personnel in dealing with aggressive or agitated patients. And in the afternoon, I'm going to look at risk management. I just want to recap what we did earlier today. The first thing we did was a brief introduction to legal issues. And I started by outlining what we mean by medical personnel or healthcare professionals. I then went on to look at workplace violence, and I gave you some definitions, and particularly the definitions from the World Health Organization. I then introduced you to the four pillars of legal issues of medical personnel or healthcare professionals in dealing with aggressive or agitated patients. The four pillars were the subject matter of a person's right to adequate, safe and healthy working environment. The second one was the regulation of rights and obligations of medical staff and healthcare professionals providing personal healthcare services under national legislation. Depending on your country, it's country specific. The third pillar was an analysis of the legal content of the patient's rights and obligations. And finally, the fourth pillar was the legal requirements for the use of violence in the medical and healthcare professionals' performance of duties against aggressive or agitated patients, or when defending against illegal or violent actions. I then went on to talk about the different various forms of violence as explained by World Health Organization. And they were the psychological, emotional abuse, the abusive behavior, the bullying, the harassment, the sexual harassment, the racial harassment, and the threats. And I'm not going to go through all of them again, but we have a clear understanding of what they mean, and that can help us then to implement policy. I then spoke about the legal perspective and what violence means from that perspective. You then heard a recording from Iveta from the Lithuanian perspective. And Iveta took you through some definitions of violence. She took you through or introduced you to the Mental Health Care Act and rules that need to be applied when dealing with physical restraint. And Iveta also recapped on the types of physical restraint. From there, I then introduced you to the legal issues from the Irish perspective. And I wanted to acknowledge the work of Mary Corkery during this session. And I recapped halfway through that video to look at the HSE, the statutory body that provide care in Ireland. It's a public system with waiting queues. There are waiting logs. I then spoke about HIQA, the Health Information and Quality Authority in Ireland that was set up to meet standards of care, to make sure that healthcare professionals working in private and public sectors reached a certain standard. We then spoke about the restraint-free environment and that we now have laws in Ireland ensuring that we have restraint-free environments in our healthcare institutions. And if for some reason we do need to have somebody restrained, it has to be prescribed by the in consultation with the multidisciplinary team, but normally prescribed by the consultant in charge of that person's care. And I also alluded to the Health and Safety and Welfare Act 2005, which is an act or a law that protects us as healthcare workers in our role as carers at work. So I'm now going to continue on, and we're going to continue looking at the legal aspects from an Irish perspective.
And this document defines restrictive procedures and the principles of good practice and states residential services for older people should comply with the Department of Health's policy set out in towards a restraint-free environment in nursing homes document. This provides, for example, that where a person is restrained, the potential benefits of any procedure must outweigh the possible negative effects on the person subject to the restrictions. The right to freedom and the need to protect people from harm must be balanced. Assault and battery. In the case of Dullahan v. Hillen 1957, it was held that assault was an act by the defendant that places the plaintiff in reasonable apprehension of an immediate battery. Therefore, the element of fear is involved. And in the case of Attorney General's reference number 6 of 1980, the tort of battery was defined as the actual intended use of unlawful force to another person without his consent or any other lawful excuse. This is therefore on the plaintiff's apprehension, and accordingly the fact that the defendant is not in a position to execute the threat is irrelevant. The plaintiff must realise or perceive that a battery is imminent. In addition, the plaintiff's apprehension must be reasonable. Thus, a reasonable person would have the belief that a battery was imminent based on the defendant's actions and the surrounding circumstances. Battery requires the mental element of intention as distinct from negligence, which requires mere carelessness. The plaintiff must show that the defendant intended the acts that constitute the battery. Therefore, if injury has been caused to the person through the negligence or carelessness of another and without apparent consent, the tort will lie in negligence and not in a criminal activity. It is a battery to perform any medical treatment or procedures on a patient without that patient's consent. And the case on this is Walsh versus Family Planning Services, where Justice O'Flaherty espoused that if there has been a failure to give a warning as to possible future risks, that would not involve the artificial concept of an assault, but rather a breach of a duty of care, giving rise to a claim in negligence. A claim of assault and battery should be confined to cases where there is no consent to the particular procedure and where it was feasible to look for a consent. False imprisonment. Again in Dullahan v. Hillen, false imprisonment was defined as the unlawful detention of the person or the unlawful restraint of his liberty. And furthermore, the detention must be such as to limit the party's freedom of motion in all directions. According to the Mental Health Act 2001, the law of false imprisonment protects a patient from illegal restrictions of their freedom. However, this only applies if the restraint is unlawful. The required elements for false imprisonment are a voluntary act by the defendant, thus the act was under the defendant's conscious control. Confinement of the plaintiff, therefore, there must be an inability of the plaintiff to go in any direction, hence the person is confined within fixed boundaries. And it is not false imprisonment for a person to release another who has become imprisonment on his property without his knowledge. Under the rules made by the Mental Health Commission, in accordance with Section 69 of the Mental Health Act 2001, a person may be placed in bodily restraint or seclusion unless it is absolutely necessary or as a last resort. The use of reasonable force only when absolutely necessary and in the patient's best interests. Patient monitored carefully and in an emergency situation where there is a need to protect the safety of the patient and restraints used only for as long as is necessary. Therefore, when a patient is restrained and their right to freedom is taken, this is only legal where there is a valid reason for such restraint and consent has been obtained unless the medical personnel can justify the patient is a danger to themselves and or others or an emergency situation exists. The defence of consent. Consent given is a full defence to false imprisonment. Such consent may be express or implied. Where consent has not been obtained, medical personnel must show that it was urgently necessary for him or her to take action without letting the patient first decide on whether he or she wishes a treatment to be carried out. Express consent may be a verbal or written agreement to the physical contact or actions of the defendant, and implied consent is imputed from the plaintiff's conduct or actions. The Assisted Decision-Making Capacity Act 2015 states a patient's ability to consent may be transient, therefore the patient's capacity must be subject to ongoing review. In regards to consent from minors, Section 23 of the Non-Fatal Offences Against the Persons Act 1997 provides that the consent of a minor who has obtained the age of 16 years to any surgical, medical or dental treatment which in the absence of consent would constitute a trespass to his or her person should be as effective as it would be if he were of full age. And where a minor, by virtue of this section, has given an effective consent to any treatment, it should not be necessary to obtain any consent for it from his or her parent or guardian. In order for a person to be restrained, it is essential that consent is obtained, and this is rooted in the Irish Constitution. Constitutional rights deriving from Article 40, essentially, are the rights to liberty, bodily integrity and privacy. The Irish Constitution guarantees a person the right to bodily integrity. Therefore, consent should be sought prior to the use of any restrictive practices. Again, the Mental Health Act 2001, Section 69, acknowledges that there will be occasions where the use of restraint will be required. This legislation states that an individual should not be placed in seclusion or bodily restraint used unless it is necessary for the purpose of treating the person or to prevent the person from harming their own self or others. The defence of necessity. It is open to a defendant to justify a trespass against a person on the grounds of necessity. The Irish Law Reform Commission has recommended that the defence of necessity, which applies in very limited situations, such as in cases of medical necessity, continue to develop on a case-by-case basis. The defence of lawful authority permits conduct that would otherwise constitute trespass to the person, where the purpose is to prevent and control antisocial behaviour. Those with lawful authority will be protected from being held liable of either assault or battery, and examples of those with lawful authority include an Garda Síochána. The defence of self-defence. A person claiming self-defence must prove at trial that the self-defence was justified. Generally, a person may use reasonable force when it appears reasonably necessary as to prevent an impending injury. A person using force in self-defence should use only so much force as is required to repel the attack. In the case of People versus AG versus Keatley, the court stated a man has a right of defending another by reasonable force against unlawful force. The majority of cases that arise in the area of trespass are concerned with the defence of self-defence. The definition of self-defence is given in Section 18 of the Non-Fatal Offences Against the Persons Act 1997. Justifiable use of force is the protection of person or property and/or prevention of crime. Section 20 of the Act gives the meaning of the use of force and related provisions, and for the purposes of the Act, a person uses force in relation to another person or property not only when he or she applies force to, but also where he or she causes an impact on the body of that person or that property. In the case of Ross v. Curtis, the adage that each case must be decided on its own facts and circumstances is particularly apposite in an action involving assault and battery. In this case, it was submitted on behalf of the defendants that where there is a risk of serious personal violence, considerable force may be used by a person in defence of himself or another, provided that the actions taken do not constitute reckless disregard for the safety of the assailant. In the case of New South Wales versus McMaster in 2016, the court stated, in all the circumstances given, the situation which confronted the defendants at the time of the actions taken by them, which they honestly thought to be necessary in the anguish of the moment, the question or test was whether the defendants believed, on reasonable grounds, that it was necessary in self-defence to do what they did. In the case of Holman v. Johnson, 1775, Lord Mansfield, commenting on the defence, he stated, "No court will lend its aid to a man who has found his cause of action upon an immoral or an illegal act, if from the plaintiff's own stating or otherwise the cause of action appears to arise ex turpi causa, or the transgression of a positive law of this country, then the court says he has no right to be assisted. It is upon that ground the court goes, not for the sake of the defendant, but because they will not lend their aid to such a plaintiff." This was reiterated in 1987 in the case of Wasson v. Chief Constable. The legal doctrine ex turpi causa states that a plaintiff will not be able to pursue a legal remedy if it arises in connection with his own illegal act. The common law has long since been refined in terms of application of this doctrine, though where applicable it can and does result in the proceedings being dismissed. In the case of Hackett versus Calla Associates in 2004, Justice Pearce considered that the modern-day ex turpi causa principle is confined to where the conduct has been so egregious that he ought not to be allowed to recover damages for an injury sustained which results from that behaviour. The basis and exercise of the power to bar recovery in tort on the ground of the plaintiff's immoral or illegal conduct is founded in the duty of the court to preserve the integrity of the legal system. The exercise of that power should be confined, therefore, to circumstances in any given case where concern for that matter arises. In the case of Donegal-Shaughnessy, the affray began in one area of Tuam, County Galway, and continued into the other area of Vicar Street. In the court's views, the events which happened in the resulting area of Vicar Street, which were more consistent with an act of retribution than with self-defence or defence of others, and constituted an assault and battery. The court stated, with regard to the defence of self-defence and the defence of others, the defendants claimed they did no more than was permitted by law. However, the court held that even if it could be said that the force was employed in self-defence, the force used in the circumstances involving the defendants striking an unarmed plaintiff with weapons was both disproportionate and excessive. Having regard to the provisions of Article 40.3 of the Constitution, it was argued that the plaintiff was entitled to the protection of the law in relation to any assault to his person, and was entitled to maintain a claim for compensation in respect of any consequent injuries, if any, sustained as a result of that assault, even in circumstances where the plaintiff initiated the affray and therefore provoked what followed so as to give rise to the defence of ex turpi causa being pleaded. It could not operate to defeat or otherwise provide a defence to the claim which arose as a result of the assault and battery which the defendants placed on the plaintiff. In the case of DF versus the Commissioner of Garda Síochána 2012, the plaintiff in these proceedings was a 28-year-old man who it was acknowledged was severely autistic. The plaintiff claimed several aspects, including damages in respect of the nominate torts of false imprisonment, assault and battery, damages for negligence and breach of duty, damages for breaches of constitutional rights, damages for breach under the European Convention of Human Rights, and the plaintiff additionally sought declaratory relief in relation to the illegality of his arrest and detention. In these circumstances, the court struck out the claim for damages for breach of constitutional right to liberty, as it is simply another way of claiming the same relief for false imprisonment. And the court stated damages can only be claimed under Section 3 of the European Convention of Human Rights Act, insofar as it is alleged that the plaintiff has suffered loss by reason of a failure of an organ of the state to perform its functions in a manner compatible with the state's obligations under the Convention. The court held that the rights protected by the EU Charter of Fundamental Rights are engaged so far as member states are concerned only when the member state in question is implementing union law within the meaning of Articles 51.2. In regards to the plaintiff's claim on this, the plaintiff claimed damages for breach of the guarantees contained in Article 3, which was physical and mental integrity. The court stated that even taking the broadest possible view of the meaning of the phrase implementing union law, it is well nigh impossible to see how the Charter could come into play in relation to events which are wholly internal to this state and in respect of which union law plays no role or part. Under no possible circumstances could it be said that the arrest of the plaintiff pursuant to a purely domestic statute was within the scope of European Union law. In regards to the plaintiff's claim based on the United Nations Convention on the Rights of Persons with Disabilities, at the time of this judgment in 2014, the Convention did not give rise to any justiciable legal rights or controversies. The UN Convention was adopted in Ireland in 2006, and Ireland signed the Convention in 2007, and further through its ratification in March 2018. However, the Disability Miscellaneous Provisions Bill 2016 has lapsed with the dissolution of the Dáil and the Seanad in Ireland, and the aim of the bill was to make changes to laws in Ireland so that Ireland keeps to what the UN Convention on the Rights of Persons with Disabilities prescribes. In the case of AC and PC versus Minister for Health in 2019, this case concerned an application to the High Court for an order pursuant to Article 40.4 of the Constitution, directing an inquiry into the legality of AC's detention. The court concluded that the claim of unlawful deprivation of liberty was not made out, and the court dismissed PC's appeal. In this case, was brought pursuant to Article 40.3 of the Irish Constitution for the release from hospital from Mrs. C, a 96-year-old woman living in St Finbarr's Hospital in Cork. She was a ward of court, having been admitted to wardship by the President of the High Court in 2016, and the case was initiated by her son, PC, in what had become a 3-year battle for him to have his mother released from hospital. The evidence before the President of the High Court included a report from Miss Patricia Hickey describing her visit to AC at the hospital on the 5th of September 2018, and a report of a consultant geriatrician, a Miss Podrigino Sullivan, who was of the opinion that AC lacked capacity. A further report was put before the court in the form of a report from consultant geriatrician Dr. Norma Hernaday, who visited AC on the 6th of May 2019. The report listed various medical conditions, including hip fractures suffered by AC in 2015, epilepsy, cognitive impairment by reason of dementia, hearing impairment, osteoporosis with a history of vertebral fracture, depression and hypertension. The report further listed the 9 medications being administered to AC on a regular basis, and the fact that AC required a hoist and 2 carers for transfer to a chair. AC was doubly incontinent, and it was Dr. Harnaday's opinion that AC had no insight into the level of care she required, and expressed the opinion that it was in AC's best interests to receive ongoing care at the hospital because she required specialist nursing and medical care which could not be provided at home. 1 week later, the committee for the ward, Miss Patricia Hickey, swore an affidavit dated the 13th of May 2019, describing her most recent visit on the 25th of April 2019. And among other things, this report clearly set out for the court the views which had been expressed by AC to Miss Hickey, namely that AC wanted to go home, that she was being kept against her will, and they were putting poison in her food. AC's daughter sent the court a handwritten letter on the 4th of June 2019 and complained about the condition of her mother's ears and alleged that she was suffering pure torture. The court concluded that the claim of unlawful deprivation of liberty was not made out and dismissed PC's appeal. One case to note is upcoming is Elizabeth Poppin versus Ireland. The UN Committee Against Torture have issued a 2020 preliminary judgment against Ireland in deciding to hear a case brought by Irish woman Elizabeth Poppin relating to her treatment in the Magdalen laundry. The allegations made are of continuing violations of the Convention, and obligations arose on the day that Ireland ratified the Convention in 2002 that continued to today to investigate, where it was credible and reasonable, grounds to believe that torture or ill treatment occurred, to ensure that there was access to legal complaints mechanisms and to ensure redress. The Irish government have 4 months to answer to Elizabeth Poppin's complaints that 1. There was no proper investigation into her human rights violations, 2. That she was barred from accessing proper legal complaints mechanisms, 3. That she is unable to access full redress that includes truth-telling, access to records and proper medical care, as she argued that she never received the proper and full extent of the medical care she was supposed to receive under the Magdalen Redress Scheme. In summary, by not using a restraint when such measure is clinically necessary could result in potential liability for the healthcare provider and the facility of a patient if a patient should sustain personal injuries. Mental Decision-Making Capacity Act 2015 states, where possible, the consent of the next of kin should be obtained to the use of restraint if the patient cannot consent. The test applied by the court would be whether the relevant healthcare professional breached their duty of care to the patient by not applying a restraint device when other, ordinary, prudent and reasonable healthcare providers would have done so in the same or similar circumstances. The general rule in regards to the application of restraint to a patient is such restraint is unlawful, except in very limited circumstances which are permitted by law. Therefore, restraint is only justified if it is of absolute necessity and can be legally justified for the benefit of the patient and for the safety of the staff member. Alternative methods should be considered before using a restraint, which include an assessment of underlying causes for the patient's behaviour, closer supervision, and individualised care. In all situations, documentary evidence must be provided that the benefits in using a restraint outweigh the risks associated with using it, and this is especially so in an emergency situation involving the absence of consent from the patient or a legal representative.
So just to sum up on that, even though I am aware that there are no students online from Ireland, I think it's very good so that it gets you to reflect on your own country's legal issues. So just to recap on that, assault and battery were the first key concepts that were mentioned, where it's unlawful force to another person without getting their consent. Battery, I think, is an important one, because if we give care and as soon as we meet a patient, we have a duty of care to them. But any treatment given by a healthcare professional or a medical person that does not have consent from the patient or the next of kin is seen as battery. So we always need to get consent. She spoke about false imprisonment and the unlawful restraint. The Mental Health Act 2001 that was introduced protects patients from illegal restrictions of their freedom. All of these acts and HICWA that have been brought into Ireland are excellent resources and protection for our patients and our clients, because it's saying that they have free restriction. However, it can put healthcare providers in a precarious position at times due to ethical and moral issues. We then went on and we looked at consent. And I suppose unless we give consent, we can talk about a full defence to false imprisonment, the necessity, we talked about self-defence and the defence to trespass. Then we moved on to ex turpi causa, common law and self-defence. Then there was a discussion where the legal cases were referred to, and the reason that these legal cases were referred to in a healthcare perspective was these were the cases that then helped to form the laws moving forward. The UN Convention was adopted in Ireland in 2006. And then finally, Mary alluded to the latest case in 2020, and she mentioned the Magdalene laundry. I just want to explain to people that are not from, that may not have heard this word. The Magdalene laundry is an example of one of many institutions in Ireland run by the church and by nuns and sisters of charity. And years ago, when women had children outside of wedlock, they were quickly taken to these institutions where they went on to give birth to their baby, and then the baby was taken away from them or adopted without their consent. And these women then were subjected to lots of labor. They had to run the institutions, do the laundry, clean floors. So these are the cases that are now coming forward in Ireland. And that was the latest one in 2020. So that's just a recap on the legal aspects in Ireland. So I'm now going to introduce you once again to a small quiz that we have. It's also on Moodle, but I think it might be good if we have a little bit of interaction and maybe we do it between ourselves. So it'll just sum up this part of the morning quite well before we move on to our afternoon sessions. So I'm going to share my screen with you once again. So we have 1 minute to do this one. The options for restricting a patient's free movement while providing health care under Irish law are A, B, C, or D. A is to grasp the patient or hold of the patient by the nurse or other person assigned by the provider, the use of bed rails, placing a patient in a net bed, and placement of a patient in a room enabling safe environment. So what are the answers to that? If you want to just quickly put them into the chat. There can be more than one answer. Anybody? Time's up. Well, there were all of them, A, B, C, and D. It's not going in for me, Sebi. Maybe it's because I've gone out of time. I'll just try this one again. The restriction of a patient's free movement by using restraint enables a healthcare professional to Ward off the threat, which is A, of an immediate life-threatening situation. Ward off the threat of immediate danger to the health of other patients. Ward off the threat of immediate danger to safety of the patient, or D, which is ward off the threat of immediate danger to the health care professional. Anybody would like to comment on them? Just check that that's correct. So they were all of them. A, B, C, and D. The restraint of a patient's movement according to the methodical recommendation is, and you can have a read of those there and tell me which one you think it is, please. Consideration, valid only, drafted for risk patients, or used anytime. Okay, well, these are just an example of the types of questions that you're going to come across. And I think maybe it might be useful, because some of these are quite specific to Ireland, that you can have a look at these yourself. But this one here is applicable to everybody. The patient restraint is always decided by a physician, a physio, a general nurse, or a paramedic. I'm sure it's the physician or the consultant or the doctor. Okay, so I'm going to stop sharing, and I think that's a good one for you to register for and to have a look at. There's some nice questions, and they give you time to answer them or to look up your PowerPoints or the presentations. Is there anybody that would like to ask any questions or to mention anything that I have gone through on the legal issues? And again, I'd like to say thank you for listening to me this morning. I hope it was some use to you. Hello, Jacob. Okay, so I might end it on that note, and I hope you have had an introduction to the legal aspects of caring for somebody who is agitated or disorientated or shows violence towards a healthcare professional. Again, we focused in on the Lithuanian aspect and onto the Irish perspective. So I appreciate we're going to probably take a longer lunch break. So we'll be leaving 15 minutes earlier, unless there's anybody that would like to have a discussion. Thank you. And I look forward to seeing you.
Thank you very much, Catrina. We'll meet Catrina again today at 1 p.m. and the subject will be risk management. Once again, let me invite you to take a look at the web pages of Safemedic project. You had the address, the link to the project. It's very easy, quick and easy to create an account and have access to the materials there. And although it is still under construction, it's almost ready and certainly usable. Well, thanks again and see you at 1.